trade secret is not just stuff you don't tell anyone about, it's what the stuff is and you know what it is and you've defined it, and you also have mechanisms to keep it a secret. IP is something that's a formalization of your idea, and everyone has a sense of what's theirs and what is not theirs. And when you do have something that's yours, it's nice to be able to take advantage of that. And so this just talks about to the effect that IP, be it patents, as is what this example pertains to, or any IP in general, which we'll get into, if you can't formalize your idea into IP, then there's no special advantage that you're going to get from that invention because you've got no vehicle by which you can enforce that ownership. And so in terms of the talk I'm going to have, I'd like people to ask themselves these questions and pick on a couple of them to focus on as I'm going through the presentation. The presentation has a lot of material in it. I'm not going to go through all of it. It's going to be available online as well. But these are things that, you know, if this is your idea and it's something that you take pride of ownership in, then these questions are things that you should ask yourself. For instance, what is the importance of the IP to you? Why do you consider it something that you should be spending your time on? How much effort did you put into it? Is it something that just fell into your lap, or did you work long and hard for it? And in those situations where you've spent a lot of resources trying to get it, it is something that you're going to want to fight for. How sophisticated are you in terms of your protection strategy for that? Is it something that you'll get to at a later date? Is it something that you're going to take proactive steps for, or not? Just what's the level that you want to get to? How much time and effort and money are you going to put towards trying to address what IP means to you and to your technology and to your business and to your customers and to your market? If you had IP, would it affect how profitable you were or not? Would it affect how much your business is worth or not? Questions to ask yourself. And if not, then that's not the place where you should be focusing, of course. In terms of the competition, no one's a silo here. Living in an ivory tower, what are your competitors doing? Do they consider it to be important or not? And we'll get to that later in terms of commercialization aspects of IP. Types of IP. So there are a number of different forms of IP. There are various uses for these different vehicles, and there's also various time periods for the monopoly that's afforded by these various forms of IP. So IP is something where you take your idea, your intellectual asset, and you formalize it in one of these ways. And if it doesn't fall into one of these ways, then there may be other ways out there, but these are the traditional forms of IP. So if it doesn't fit into one of these, then maybe you don't have IP. But so there's patents is mine. I will talk about the rest very, very briefly. Copyright is basically a form of expression, and in terms of what a patent agent thinks of copyright, it just applies to all the original literary, dramatic, and musical and artistic works, and has a lifetime of protection for the author. It definitely stems from an individual, and then you get plus 50 years on that. There are some things coming in through the TPP that's going to affect that timeline in terms of lifetime of protection plus, but that's the basic gist for copyright. Trademarks are, again, has a time period that's potentially indefinite, very valuable form of IP for recognition of your brand in the marketplace, to protect against knockoffs, because your name has to be associated with your product. It's a monopoly given for the mark associated with certain wares and services, and the mark can be what we're all familiar with, the word or a phrase. It can be a picture, it can be a sound, depending on different countries have different regimes for how to protect and what's protectable under a trademark. Industrial design is a form of a patent, and it is for the substance. It is for the form of the article. So for the ornamentation, patterns and shapes. It has a very limited lifespan as compared to a full functional patent, 10 years. The shape of a Coke bottle, things like this are all, in terms of visually, what's distinctive. It's not applicable at all to the function of the article. So how the article functions has nothing to do with an industrial design. Trade secret is information that originates and is maintained out of the public view. So it's those intellectual assets that you decide to keep out of the public view. It doesn't fall under any of the others which are publicly viewable, being patented technology, copyrights or trademarks or designs. It's basically kept under lock and key. You clearly define a trade secret is not just stuff you don't tell anyone about. It's what the stuff is, and you know what it is, and you've defined it. And you also have mechanisms to keep it secret. So keeping it on your desk or in the hallway is not a trade secret. There's a couple on there, such as the Google algorithms are an example, the Coca-Cola formula. There are some considerations for US. There's a stat bar in the US that if you keep something a trade secret, but you practice the invention, after a year, then you're not allowed to patent it. So you do pick one path versus the other in that example. In Canada and in other jurisdictions, you can keep something secret for 10 years and then patent it. But in the US, you don't necessarily have that option. So just a little hiccup there for trade secrets. Patents, more my domain, 20-year monopoly. It does have a lot of applications, like what Anthony was saying. You can pretty well patent anything. There are some statutory exceptions, but on the whole, you can patent most things. As to whether you want to patent them or not, or should, it's a different matter. The only catch with patents is that you have to fully disclose your invention and how to practice it in the application that gets published. And if you don't get the patent, then that may leave you in an awkward position. So that's something that you have to bear in mind, and that's why, like what Anthony was saying as well, that you should be careful with how the application's drafted. Okay. So I have here a couple of points, quotes from people talking about patents. I'd just like to draw your attention to what people think about them. So Bill Gates, for instance, says that established companies have an interest in excluding future competitors. Maybe one reason why you should be concerned about patents. Tim Cook from Apple talks about it's overhead, but if we could find a way to settle this, talking about in terms of patent lawsuits and patent litigation. Again, we'll talk about it's not fun to be on the wrong side of a patent lawsuit, but at the same time, to be on that without patents is even more awkward at times. From Samsung's position is Apple couldn't do what they do unless they had license to Samsung-owned patents. So that's an interesting comment. That's their position. Verisign, .com, .net. Everyone uses that technology every day. It talks about revenue streams that one can realize, because patents, like all IP, are a form of property. They can be bought, transferred, sold, owned, and so they do have value. So now I'm just going to talk about a little bit about what is a patent. So a couple slides on this, because I'm not going to go through in too much detail about patent applications, more about the application of it and how to get to that stage versus how to draft one. But you do have a couple of requirements. One is there's got to be some problem or difficulty in the marketplace and figure out what you're going to address. So there is a technical problem and a solution type approach. The subject matter of the patent application, what you describe and talk about, has to be considered new, meaning it wasn't known before the filing date of the application. There are some exceptions to that, but that's a general rule that one would follow. Non-obvious means that it's not just, it's seen to be something more than just making something larger or making something faster or just automating something that's known. There's got to be something that, that kind of tweaks that technology into its own in terms of applying in that direction. Applicable to industry, it has to be something that's useful. And it has to work every time you do it, like the cookbook, like the recipe. It can't be left to chance. In terms of the application components, the composition of the actual document, you've got 3 basic sections. You have the background, which sets out the contextual story of what you've set out to solve and why it's important. It focuses you in terms of, you know, why did you set down the path that you set down, and then why is what you're doing addressing those objectives. There's the meat of the application in terms of the description and the drawings. You've got to tell someone how you do it in good detail. Nothing can be left up to the imagination. Someone skilled in that area, so if it's in the area of computers, you expect someone, or in the area of encryption, you expect someone to have those basic building blocks of knowledge, and then they should be able to read it like a cookbook. Claims then carve out certain sections of the detailed description and drawings that maps out what the fence is around what you consider to be yours, and to be able to exclude others from the marketplace based on that. Going next to the main part of of my talk is about managing and commercializing IP. So, of course, you ask yourself the question, you know, should we start here? And unless you're in the extermination business, maybe not. So needless to say, that the main point of this slide is in the center there, which is the IP committee. So really is looking at all the disclosures you're getting from different parts of the company, from different people, talking to people who understand what that means with respect to the company, with respect to the industry, and then deciding, making an active decision at 4 as to what category it falls under. Copyright's not there, but that's just the way it is. So you've got trademarks, patent applications, designs, trade secrets. Whether you're just going to publish it and forget it, it's not going to be your intellectual property. You're just going to make it available free of charge to the market, or whether you're going to trademark it. But this slide is meant to show that you do have to have some systematic way of going through the process and making the decision as to whether reject, we're not going to pursue this, we're just going to publish it and make it known and be more of a PR exercise, or we're going to try to formalize it and we're going to go through the proper steps to get there. The group discussion is important when you're talking to your key innovators, be it in groups or individuals. There are different forms in which you can get the information out on the table so you can discuss it and say, is this something that as a company we would like to pursue, or is it something that we're going to drop? And so there's a lot of tips and points on here to think about in terms of how to get information from an individual or how to get it in a group session. What's important, though, is the bottom box, which is providing the direction, kind of coaching. So you do kind of have to guide both what the information is that you're getting, and then be able to disseminate that into, is this something that's useful for the marketplace or not? What types of problems does it address? Where did the idea come from? If it came from when you're working at your former company, that's probably not the one we want to pursue because it's theirs, not ours. All these important questions to ask yourself. Okay, another quote. So you can do all of that, and I've seen companies try to do it, and they get everything set up, and they don't do it very well, they end up failing, and you go back to them and you're talking about what's going on. And the biggest stumbling block that all companies get to is whether it's part of the culture or whether it's not, whether it's reinforced or whether it's not, whether it's important or whether it's not. It can't grow by itself and become important. It has to be stated as important. So the biggest thing, as is performance in school, and you know, lots of studies have shown that, is the parent. Same thing with companies. It is management. Management has to live and breathe this. Otherwise, it's not going to go anywhere. You can go back to that spreadsheet or that chart that I had. You can go and look at all the points about what to do and how to have the meetings and how to get the information and analyze it. But it'll never get out the other end unless management's front and center on your ideas. Oh, and you need a great patent agent too. Must take into account 3 factors. Okay, so budget, certainly, and it's not just at the time of filing, it's also post-filing, and the pendency of your applications. We'll talk about a little bit about issued patents versus pending applications and how those are important together, and also the trade-off between information and scope. You only really have to describe enough to practice the invention. You don't have to give everything away. So being able to make that decision as to what you're going to talk about in the application, what you want to protect as an invention, and what you maybe want to keep for another day as a trade secret or a subsequent patent application, and so on. It is important in going over all of this, as you can see with the time and the budget and what information you're going to give away and not, is again your patent agent, the person you're speaking to put your intellectual assets into patent IP or any other IP, has to understand your technology, your business, where you're going, why you're going, kept updated in terms of the changes that you're making, any questions that you can have. It really is a pretty custom relationship and quite important. So these are some of the commercial considerations. I'm not going to go through them too much. There's a couple quotes on there in terms of what good, solid IP-based companies are that not necessarily started out as IP-based companies, but are growing in that direction, and are going to see some very positive aspects in terms of leveraging their portfolios. And there's a lot of commercial considerations there in terms of whether your innovations are something that you use or your patents are used to advertise what your company is doing, being on the cutting edge, cross-licensing, business flexibility, getting into markets that you may not otherwise be able to get into, insurance against being picked on by your competitors and their patent applications, valuation factors, lots of things to consider. Magna is one example. It's a company that I work for, and they're a company that did a couple things right, and one is that they realized that their industry was one that was marked by constant innovation and required special internal processes to recognize those innovations and to commercialize on them. And they did that through looking for patents that are related to their core business operations. If you have the luxury to worry about other companies' core business operations, that's great, but it's great to center on your own.